From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Fifth Circuit Court of Appeals strikes down President Obama's deferred action for the so-called Dreamers. But will this change the incentives in Washington for government by executive action? Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Alicia Finley and Kim Strassel. Welcome to you both. It was more than 10 years ago now, June 15th, 2012, that the Department of Homeland Security under President Obama issued its memorandum on prosecutorial discretion with respect to individuals who came to the United States as children. This is a group that is often called Dreamers. And the policy as it has operated for about a decade, this is from the memo, is there's some general parameters. People applying have to be brought to the U.S. when they were under the age of 16. They have to have continuously lived in the U.S. for a certain period. They can't have been convicted of a felony or a serious crime. They have to be in school or graduated from school or honorably discharged from military service. And then they could get deferred action from deportation and immigration law enforcement. They could get authorization to work in the U.S. They could get eligibility for Social Security and programs like that. And Alicia, now we stand here a decade later, and the Fifth Circuit has ruled that this DACA memorandum was illegal. So why don't you start by just telling us a little bit about what the court said here?
Basically, it ruled that it was illegal both under the Administrative Procedure Act, which sets forth procedures in which regulatory executive agencies have to follow notice and comment and consider a wide range of factors before taking final actions. And it ruled that this 2012 memorandum violated the Administrative Procedures Act because it didn't do any of this. And actually, the district court had remanded it, and DHS, the Department of Homeland Security, then went through a final agency rulemaking. But the Fifth Circuit said, we're not going to review that right now. We were just going to review the 2012 memorandum. What the DHS is doing here, which it did, by the way, in the Remain in Mexico case, is it's somewhat trying to moot the case by saying, okay, well, now we're going to issue a new rulemaking. You have to review it. The current case is moot because now we dotted our I's and crossed our T's, and we did do what the district court decided, so there's a new case in controversy. Fifth Circuit isn't allowing them to get away with this. Second, what they did do in the Fifth Circuit opinion is they ruled on the substantive merits that the 2012 memorandum exceeded the agency's statutory authority under the Immigration and Nationalization Act. There isn't any clear authorization in the law to do what it did. So that violated the major questions doctrine, which the Supreme Court elucidated just recently in the West Virginia v. EPA case, but also kind of on the Chevron deference grounds. The court also ruled against the agency in part because there actually is no ambiguity in the text. This is just flat out illegal. It creates a substantive right for these Dreamers, provides work authorizations for them to stay in the country. This is not prosecutorial discretion. It's really not doing this, considering these cases on a case-by-case basis. It's basically providing blanket legalization for these up to 1.5 million undocumented immigrants.
I'll read a few quotes from the ruling just to underline that. Here's one. There is no clear congressional authorization for the power that DHS claims. The court says declining to prosecute does not transform presence deemed unlawful by Congress into lawful presence and confer eligibility for otherwise available benefits. Notable here, too, that there's also a ruling against the DACA memo on Administrative Procedure Act grounds. And the administration had argued that the DACA memo was discretion. It doesn't create any substantive rights. And the Fifth Circuit did not buy that whatsoever. It says that DACA created a detailed, streamlined process for granting enormously significant predefined benefits to over 800,000 people. This constitutes a substantive rule because DACA did not undergo notice and comment. It violates the procedural requirements of the APA. And Kim, I mean, one thing that is so odd about this, I guess, is that didn't everybody know that this was beyond the president's power in the first place? And I'll go back to the quotes from President Obama. He was campaigning in 2011 and was asked about prosecutorial discretion. There is a program called Temporary Protective Status for people who are in the country when something like a natural disaster or a revolution happens in their home country. And President Obama said that that would not be appropriate because a lot of these people who are dreamers, their families came here for economic opportunity. And then here's a quote. He says, with respect to the notion that I can just suspend deportations through executive order, that's just not the case because there are laws on the books that Congress has passed. And I know that everybody here at Bell, he was campaigning at a college, I believe, is studying hard. So you know that we've got three branches of government. Congress passes the law. The executive branch's job is to enforce and implement those laws, and then the judiciary has to interpret the laws. There are enough laws on the books by Congress that are very clear in terms of how we have to enforce our immigration system that for me to simply, through executive order, ignore those congressional mandates would not conform to my appropriate role as president. And of course, in retrospect, Kim, we now know that was about a year before he would change his mind and issue the DACA memorandum. But here we are 10 years later, I think, solving the legal question that we sort of knew the answer to all along.
Yes, it's a bit like Joe Biden acknowledging not so very long ago that he didn't simply wave a wand and get rid of student loan debt and then caving to pressure and suddenly deciding that he does. What the Obama administration did here is, yes, the Department of Homeland Security, under the laws we have on the books, has some prosecutorial discretion to choose whether or not to bring enforcement actions against undocumented immigrants who are here illegally. But it was always understood that that was meant to be exercised on a case-by-case basis. And the Obama administration just drove a truck through that and decided that he would just decree blanket immunity for hundreds of thousands of people, which is not the way that Congress ever intended prosecutorial discretion to be used. I think it was put most simply in this opinion by the Fifth Circuit, which was authored by the Chief Judge, Priscilla Richmond. She wrote, DACA creates a new class of otherwise removable aliens who may obtain lawful presence, work authorization, and associated benefits. Congress determined which aliens can receive these benefits, and it did not include DACA among them. I mean, case closed. So that's really the important part of this ruling, because we were talking about how this was also caught up in the Administrative Procedures Act. But as Alicia was noting, the Biden administration's been trying to get around that by saying we've issued a new rule and we have dotted our I's and crossed our T's, and so that doesn't really matter. But getting around this substantive ruling, this part saying that this is flat out in contravention of the Immigration and Naturalization Act, is a bigger problem for the administration because this has now been sent back down to the district court. And it will have to analyze the new rule that the administration is finalizing on the basis of this ruling and the substantive problems.
And Alicia, the other thing to keep in mind here is the tangled course of the legal arguments about DACA, because, correct me if I'm wrong, but if my memory serves, there was the initial memorandum. Then the Obama administration tried to expand it to parents of dreamers. That was the DAPA program. And that was struck down by the courts. But at the same time, the litigation against DACA has not gone as straightforwardly. President Trump won his election bid in 2016. He came in and his Department of Homeland Security tried to rescind the original DACA memorandum. Then that went to the Supreme Court, which said that the rescission was arbitrary and capricious, more or less. Then President Trump lost his reelection bid, and now we have President Biden trying to reinforce DACA with a new rule from the Department of Homeland Security. So, I mean, Alicia, does that sort of back and forth explain what took so long, why we're now 10 years away from the original memorandum before we get a circuit court to weigh in here?
Right. It took Trump rescinding the program, which it did actually, ironically, under threat from the GOP attorneys generals, if you recall, who threatened to sue if it didn't. And then it winded up in federal court and then went to the Supreme Court. And a majority saved the program, in part by finding some quibbles, and perhaps they're justified, with how the Trump administration rescinded the program, that it didn't consider certain reliance interests by the states. It didn't distinguish between like the actual benefits of the program and just the forbearance in terms of not actually deporting the dreamers. But if you recall, also, there were three justices, Alito, Thomas, and Gorsuch, who believed that the program should just be, and wrote in concurrences that they believed that the DACA program was flat out illegal. It exceeded the statutory authority of the government. And we argued that it did as well at the time. And that basically that the Supreme Court was just punting on the issue and that they would eventually have to take it up again. And here we are. The Fifth Circuit, was ruling almost ensures that this will eventually go back up to the Supreme Court, even though it is now remanded to the district court for further considerations, because the Biden administration will no doubt appeal in any event to the Supreme Court. Perhaps they'll try to drag this case out further past this election. But I could also see some kind of gamemanship and strategic timing in trying to get the Supreme Court to hear the case perhaps next term or in 2023 for a decision to land flat out before the November 2024 election. I don't know which party actually benefits from that. I think Democrats may believe that they will, but in the same way that they perhaps have benefited actually from the Supreme Court's overturning Roe v. Wade and putting the pressure on Republicans to do something, especially if they gain control of Congress in this next midterm election. And then they can beat up Republicans for not providing the legal status, some kind of middle ground or some kind of compromise that allows these dreamers to stay in the country, to work, and put the onus on Republicans in Congress to do something.